Good evening, you're watching the Digital Age, and I'm James Goodale. Recently, the House passed a SHIELD law. That's a law that protects reporters from testifying about their sources. The House passed that by the margin of 398 to 21. Immediately following that vote, George Bush came out and says, I'm going to veto it. Now, the question for us tonight is George Bush really going to veto a bill when it has that kind of margin? And here to discuss that question with us tonight is Marty London. He is of counsel to the Paul Weiss law firm. He has made some part of his living suing the press. And on the right, I have George Freeman, who is vice president and assistant general counsel for the New York Times Company, and he has been heavily involved in the drafting of this SHIELD law that passed the House by that tremendous margin. So I'm going to start with you, George.
Okay.
Why did the House pass this bill by such a large margin? How does the bill work, and why is it so terrific, at least in the light of the legislators who voted for it?
Well, the first thing is that the bill basically protects the free flow of information. That's what it's called, the Free Flow of Information Act. It's not so much to protect reporters as it is to ensure that news information is going to get to the public. Because a lot of the news and the information that we get, from the abuses at Walter Reed Hospital to Abu Ghraib to the NSA domestic eavesdropping program to the terror camps in Eastern Europe, those stories, all within the last couple of years, were given to the press and given to the public by confidential sources. And those folks wouldn't come forward, wouldn't tell the journalists, and through the journalists, the public, their stories of these problems, were it not for the fact that they could be guaranteed confidentiality. Because they might be committing some sort of crime, they might be committing a violation, they might be fired if they were connected to giving that news to the public. So it's important that we get whistleblowers, we have government critics who can give their side of the story to the press and to the public, but be protected in doing so, and that's what this law is all about.
Do you agree that this law protects whistleblowers and it's not aimed at protecting reporters?
This law demonstrates why Congress is the only institution I know who ranks lower in their public approval ratings than the President of the United States. George's comments just now demonstrated why the law is unnecessary. He said all these people about Walter Reed and NSA and the terror camps wouldn't come forward if they didn't have confidentiality. All of these people came forward without such a law. So the law is totally unnecessary. All these people came forward without the law. They came forward with, there's a long history of confidential sources that came forward without the law. So the law is totally unnecessary. The notion that the free flow of information will be spiked unless with the law is totally speculative. The Supreme Court said it was speculative. The law is upside down. It gives a privilege to reporters who are untrained, unschooled, undisciplined, unmannered. They have total discretion whether to invoke the privilege or not. The privilege protects people who have committed rape, murder. People who plan a crime are covered by this law. If the journalist, be he a pajama-clad blogger who made $9 from Google last month, he's a journalist under this cockamamie bill. If he's a journalist, he can decide, not the source. He can decide. You know, George, you and I are lawyers, and we are aware of the law of privilege. And the privilege means that you can go to your lawyer, your priest, your doctor, and tell him a secret that's important for your health or your legal status, and the lawyer is then obliged to invoke the privilege on behalf of the source. That's not what this bill says. This bill doesn't give the privilege to the source. It gives the privilege to the journalist and doesn't give him any standards by which to invoke the privilege. Furthermore, if a client comes to me and says, I'm planning to rob a bank, Marty, at 3 o'clock in the morning, I'm going to tunnel into the bank and steal the money, I say, you know what? I'm not keeping that a secret because my ethical obligation is to reveal a planned crime. Where does it say that in this bill?
It does, if you read it, actually.
No, I actually read it very much. You know what? The only time it protects it accepts the revelation of a source if there's imminent harm to imminent death or physical harm or imminent terrorist harm to the United States. A bank robbery is nowhere covered by the bill. And if you want me to read the section, I'll read it. It's a ridiculous bill. It's a bill that was drafted by, of all people, as you just put it, George Freeman. He hasn't the public interest in his mind. He has the New York Times interest in his mind. That's who drafted the bill. It is an absurd bill. It is full of nonsense. You know what this bill does? This bill has an exception. It says you can't get the source unless the source has revealed to the reporter a trade secret or a health secret or a privacy secret. Mind you, it doesn't say anything about nuclear secrets. You could give a reporter a nuclear secret and it's not protected.
It's not true.
As long as once the nuclear secret is published, then there's no longer, by revealing the source, you're not preventing imminent harm to the United States. The secret is already out. And that criticism was before the Congress when they passed that bill. Read the committee reports. They brought that to the attention of the committee. The committee was so eager to satisfy the press and to say, I'm a good guy, write nice things about me in my editorial. They ignored all of those comments. Ridiculous bill.
All right, now, Marty has made 25 points.
Of which 23 are probably wrong.
But I think maybe
Read the bill. Every word I said is absolutely accurate.
you might just want to start with a tiny explanation how the bill works, because Marty's got all these dysfunctions that he sees in the bill, and maybe we ought to understand how
I'd
the bill
love
works.
to use my time rather rebutting the 23
okay,
errors he made,
no,
but I'll do both.
Go ahead. A couple of minutes.
I tell you what, when you go and read the bill after this program and you discover that everything I said was accurate, will you just send me a note and
Absolutely.
say, Marty, you were right. Thank
Absolutely.
you.
I'll tell you why
I'm
you're
happy.
wrong right now. But the way the bill works, I mean,
Simply, you know.
basically simply is that if a reporter is compelled to testify, is subpoenaed, in a case he has nothing to do with, by the way, he's not a defendant. He just happens to have be a witness perhaps, or have some evidence, sometimes tangential evidence, like anyone else, he can be subpoenaed. And now this bill says if that reporter is subpoenaed, particularly to give information about a confidential source, then he may be able to deflect that subpoena, may not have to be compelled to testify, if he can show that the government or whoever subpoenaing him could go elsewhere, if the information isn't really critical to the case. And in the end, there's also a balancing test of where is the public interest? Is there a greater public interest in having him testify or in shielding him so that he continue to get information of this type from the whistleblower, from the government critic, so that the public can be better informed?
Now, let me just interrupt for a second. So the reason I asked you to say that is I just wanted to make clear to the audience that we're not talking about an absolute bill where the press never has to testify. Press has to testify if certain tests are met. It's a so-called qualified bill. Okay, now go ahead. Go after him.
I mean, I'd start out with the fact that the vote in the House of Representatives, not the most liberal, pro-media body, I would say, and I think even Marty would agree with that, was 398 to 21.
That's because they understood the bill the way you just described it, which is wrong. The bill specifically
They
says...
had drafted the bill, Marty, so presumably they understood what they drafted.
Oh, well, that's a...
But let me
That's a rash presumption. The bill... The bill specifically says that where the testimony could reveal a source or provide information that could lead to a source, then in order to make the guy testify, you have to show that there is you have to prevent an act of terrorism against the United States or other specified harm to national security to prevent the harm. So you're looking at future harm.
No, it also has in there past harm. That's wrong. It has in there past harm. That was amended.
With the obligation to prevent the harm or disclosure of the identity of such source is necessary to prevent imminent death. It's to prevent, so
which is the same as a lawyer's privilege, by the way.
The lawyer
can break the privilege to prevent a future crime.
But a future crime. But not. Oh, this only covers death or harm to the United States of America. It doesn't cover the bank robbery. So that's absolutely wrong. Second of all,
first of all, let me interrupt.
Let me give George
really
a second. He says the bill is unnecessary.
It's not even a
That's
realistic.
his first
That's
argument.
not even a realistic point, because reporters all the time
we don't have
talk
bank
to
robberies, so I guess
talk
it's
to the
not
no.
realistic.
Reporters will come forward anyhow in those instances. The notion that a reporter won't talk to the authorities
by what
to prevent
standard do we
real
know
harm.
that? By what standard?
By the standard of realistic history. That's all.
What, ethical journalism?
Realistic
Journalistic
history.
ethics?
That's what's happened in the past. But let me get to the nub of the point.
He says it's unnecessary.
Let me tell you why it's not unnecessary. Look at the two most recent examples. We have in the Balco case, this is the case of baseball and steroids.
Balco.
We have some reporters who basically got grand jury transcripts that they shouldn't have gotten.
Where'd they get them?
They were leaked to them in violation of a judge's protective order, okay? The result was stories about steroids in baseball. The result was congressional hearings, reform in baseball, and the two reporters were congratulated by the president. There's film of President Bush putting their arm around them,
and they won journalism awards
great
too,
job, great job. Yet they were inches away from jail because they didn't testify upon compulsion, didn't testify as to who gave them that information.
Now,
look at the balance. No.
Can I
look
talk
at the
about
balance.
the Balco case?
Look at the balance,
I'm sorry,
okay? On the one hand, you have reform with steroids in sports. You have, hopefully, and I'm sure, Marty, you have kids who, as a result of this reporting and as a result of the reforms, didn't do steroids when otherwise they might have. That's what you get for the reporting, for the fact that these sources gave this information to the press. And yet against that, you have the reporters going to jail. I mean, that's a crazy system.
Yeah,
Why
how about
should they
that
go to
balance?
jail?
Why should the reporters go to jail and your kids,
now,
instead of your kids knowing about steroids?
Now let me tell you the whole Balco story. You got exactly.
The whole Balco is irrelevant to the points I've just made.
You're the one who brought up Balco, not me. In Balco, the reporters got grand jury transcripts, and for those people who don't watching this program don't know, it's against the law to reveal a grand jury transcript. And if you don't like it, go to the legislature. You don't take the law into your own hands and break the law. The lawyers got grand jury transcripts. They weren't allowed to reveal them to anybody. They gave the grand jury transcript. Now, you want to hear about chutzpah? The lawyers gave the grand jury transcripts. The lawyers gave it's a legal term. The lawyers gave the grand jury transcripts to the reporters. The reporters wrote articles. They were great articles, sensational articles.
So they should go to jail
For
writing those great
about
articles.
The grand jury transcripts. The lawyer who gave them the grand jury transcripts then goes to the court and makes a motion on behalf of his client, who's a defendant, to dismiss the prosecution on the ground that the prosecution leaked the grand jury transcripts.
Well, what's that got to reporters, Marty?
All right, so I'll come to this.
About a lawyer who's no good.
No, because the reporter knew that the lawyer was perpetrating a fraud on the court. The reporter knew the lawyer was perpetrating a fraud. You know what the reporter did? The reporter went back to the lawyer, continued the fraud on the court.
But the reporting had already been done. That's not the point.
You're not focusing on the point of George's argument.
You got to listen.
Yeah, okay.
After the lawyer, with the aid of the reporters, perpetrates the fraud on the court, the reporter then goes back to the lawyer, looks at new transcripts, writes new articles, knowing all the time that every step that the reporter was taking was the perpetration of a fraud on the court. The reporters were dupes. The lawyer was using the reporters. Can you imagine? This is sort of
Marty,
like
you're missing the point. We're talking about the shield law. Why is there a shield law? There's a shield law to protect reporting that got out that was useful to the public.
These reporters should have gone to jail. They should have gone to jail.
They should have gone.
They should have gone to jail
because of their good report. Because they're congratulated by the president.
Because they broke the law.
Let me give you an example. Let me give you a second example.
The president congratulated them is one of two things.
Why did they break the law?
Why did they break the law?
Yeah.
Because they helped. Because they published a grand jury transcript and they knew it was wrong. Because this guy was using their publication of the grand jury transcript to deceive the court. They knew he was deceiving of the court, and they cooperated with him.
Let me give you a second example.
They should get an award for that.
What about Judy Miller? Now I know you'll like that one too. Judy Miller served 85 days in jail for not testifying about a source after she did not publish any information about the matter.
You know, you're too smart. Publication has nothing to do with it.
The defendant in the case...
She was asked about whether somebody violated national security laws.
She wasn't a defendant in the case,
She was asked whether somebody violated national security laws. She said, I won't tell you. I won't tell you who it is.
What happened?
What's it got to do with publication?
Marty, what happened?
It's a red herring.
The witness Judy Miller.
Shame on you.
Didn't have anything to do with anything. Ends up serving 85 days in jail. The defendant, who's convicted by a jury, ends up serving no time in jail. Is that fair that the reporter, let's beat up on the reporter, send her to jail,
you know what?
but let's let the defendant off?
Not
the
fair.
defendant in the case rather than the third-party witness who had nothing to do with it.
My law firm represented that defendant, so I'm not going to comment about that at all. But let me ask you this question, George, because you are a lawyer, as is Goodale, I think. He was a lawyer once. You're a lawyer, and we believe in the rule of law, and we believe that everybody must obey the rule of law. You and the Reporters Committee for Reporters' Rights or First Amendment rights or whatever their title is, are promoting this law in which you ask for all kinds of privileges with certain exceptions, I agree, though the exceptions are ridiculously small, privilege not to testify, not to give grand jury testimony. So you set up a process by which it's determined whether they are obliged to testify or not. And then you say, here's the process I propose, here are the rules I propose, here is the way I'm going to play this game, and we're going to submit it to an impartial guy who's a judge. And you know, by the way, if the judge rules against me, I'm not going to obey him anyway.
Well, we don't know that. There is no law yet. So let's have the law passed, and we'll see if you turn out to be a prophet or not, Marty.
Mr. Goodale and Mr. Freeman and the committee
Mr. Goodale, how am I into this?
Because you guys have said to the reporters, don't obey a court order.
I've never said that to any reporter.
Well, Goodale has said it, and the committee that sponsors this bill, the Reporters Committee, said that. So if you want a bill, and I think that there should be a bill, this one sucks. But if you want a bill,
is that a legal term?
That's a legal term. It goes with chutzpah. If you want a bill, there should be a thing at the bottom of the bill in which it says, when the reporter challenges the subpoena and says it is against the law, it's against the provisions of the law, he ought to be obliged to submit to the court under seal the information asked for in the subpoena. So if he goes through the entire process, the legal process, and he loses, then the government gets the information. Well, what's the matter with that?
Well, why don't we just pick up on his major point, which is, you answered it in part, but his point is this. If the bill is passed, will the reporters and the press institutions obey it? What is your view on that? I mean, your answer was wait till we get to that point, but so I asked the question again.
It's hard. Obviously it's hard to know, and it depends on an individual case. I mean, there are times, I'm sure, when an individual's conscience will get in the way. There are other times, I think, where if this law exists, I mean, the fact is, if you go through the state shield laws, these clashes don't come up that much because the law sets out what the guidelines are. It regulates behavior. In the federal courts, I mean, that's the weird thing, that people say this is scary, we shouldn't do this. A law just like this is in 32 or 33 now of the 50 states, and other 18 states have basically the same kind of protections given through the courts. Prosecutions have taken place, the bank robberies have been avoided. We haven't had a problem in New York State, in New Jersey, which have two of the strongest shield laws in the country. So why are we even debating this? The states that are in charge of most of our criminal systems have had these laws for decades. What's the big deal?
Yeah, what's the big deal? What's the answer to that? And let me just point out, as long as I got the mic here for 2 seconds, that we're talking about, for the audience, to make it clear to the audience, that we're talking about a law that protects the reporters in federal courts. Those are...
Doesn't protect the...
Well, let me just finish, because I want to point out the difference between federal courts and state courts. The state courts have their rules. Federal courts are going to have their rules if this bill passes. And George's point was, just to reiterate it, is that in the states, there are 32 states that have something like this, and all these horrible things haven't happened. So to repeat what he just said, what's the big deal, Marty?
Well, let me just one other thing, which is that the law is supposed to order people's behavior. It's supposed to tell you how you should behave. So if you're a reporter, and Marty, let's say you're a reporter, because I think that'd be a good position for you.
Under this bill, I am.
If you're a reporter and you're sitting there with a source, you have no idea what the law is going to be, because you don't know if the case that you're going to be subpoenaed in 3 years from now is going to end up in state court or federal court. That in itself is a reason to have this bill, so that at least there's a parallel situation.
Yeah.
no matter what court the case turns out fortuitously to be in.
George, I'm not arguing against any bill. I think there should be a bill. I don't think that anyone has given any sort of careful thought to this bill.
I got to tell you, in Congress, they marked it up for a full day. They debated,
well,
you know, I think 18 amendments and so on.
They marked it up. Listen, I read those hearings. If you think that the members of the 329 members of Congress had any idea what was in this bill, all you can do is look at the hearings. They had no idea what was in this bill. There is nothing wrong with a bill. The exclusions in this bill are ridiculous, because they don't cover past crimes, they only cover future crimes.
Isn't that parallel to the lawyer's privilege, Marty?
No.
I mean, if your client tells you something that he did in the past, you're not going to break the privilege,
listen,
are you?
But as a lawyer, I have a set of ethics that requires me when to invoke the privilege and when not. There's nothing in this bill that says when the reporter should invoke the privilege and when he should not invoke the privilege. It's entirely discretionary on the part of the reporter. The source has no rights under this bill.
That's because the bill is for the privilege is really for the public. That's what you're failing to understand.
The privilege is for the reporter, and if the reporter should decide.
What's the purpose for that? The purpose is that the reporter can be a conduit for that information to go to the public.
You know what?
This is a much more important privilege than a lawyer-client privilege. That involves two people. This involves information getting to the public about our government. What's more important than that?
Well, two things. One, there's nothing in the bill that prevents many reporters, and I know you will agree, do testify when they get subpoenas, and many reporters do obey court orders. The question of whether or not to testify is entirely in the discretion of the reporter. That is not true with the lawyer-client privilege. If somebody goes and makes a confession to a priest, the priest doesn't get to say, you know, I don't really like this guy, I don't like the color of his skin, I don't like his politics, I think I'm going to reveal his confession. The reporter can do that under this bill, but the priest can't.
Why can't the priest do it? The priest can do it too.
No, the priest has a set of ethical, professional
so does a journalist.
No, I'm sorry.
There's no distinction there.
The
journalist isn't regulated by government, but neither is the priest, for that matter. What's the difference?
Reveal a client's confidence, I'll be disbarred.
The priest won't be defrocked.
Oh, he might be. I don't know the church rules. If I reveal a client's confidence, I can be disbarred, and if a doctor reveals a client's confidence, he can be sanctioned by the medical agency. If a reporter reveals a source, what happens to him? Nothing. He probably gets an award from the president.
All right, now, gentlemen, let's turn all this discussion around to the fine point of whether President Bush will really veto a bill that has passed 398 to 21.
The number's getting bigger and bigger as we go on.
Not 398 to 21 is right.
398? I thought it was 329, but go ahead.
No.
Okay, now, George, give me some views of the politics of this. You've been in the middle of this fight, then we can hear the man on the street.
The politics partly is interesting because a key point, other than the president, is going to be the Attorney General. The Attorney General, obviously, is under confirmation here, is Judge Mukasey, who, interestingly, once used to argue for the press in these cases. He was once a press lawyer many eons ago.
Press lawyer.
Now, on the other hand, he's testified in his hearings, confirmation hearings, that he doesn't think this is necessary, and all that's needed is to change Department of Justice guidelines, which is a totally misguided and just wrong statement, because this law and the problem deals not only with cases brought by the Department of Justice, but deals with civil cases, cases brought by other government agencies, cases brought by special prosecutors, certainly been visible in the news, none of which are governed by the Department of Justice guidelines. So I don't know whether he was trying to fudge and kind of finesse the whole point, or he just was wrong. But Judge Mukasey is a smart guy who got it totally wrong.
But wait a minute, George.
The reason I'm saying that is that he's going to be an important factor, presumably, as to whether or not the president's going to veto the bill. I mean, he's the guy who's going to be looked to, I would think.
But the Justice Department already opposed it.
They've opposed it, that's right.
I mean, he's got a special new...
I just wonder whether
he may have the president's ear, and you worry about him having the president's ear.
Well, I don't know if I worry about it. I wonder whether he wants to start out his new administration in the Justice Department as being the main reason why there's going to be this conflict and this veto and this fight. Incidentally, in the House, it looks like the veto would be able to be overridden.
Well, I would think so.
In the Senate, we don't know what's going to happen in the Senate.
Unless they come to their senses.
Wait a minute. No, wait.
Yes.
I want you to focus on the politics of this for a moment, okay?
Yes.
You're the man on the street, not the super anti-press lawyer. Because the real question here is, since there's a huge margin in the House, we have to assume it goes back to the House, it's veto-proof. The real question is the Senate. So,
Right.
so the question for the Senate becomes, you need 60 votes to override a veto. Now, in light of what you view the bill and in light of your common sense view of politics, what do you think?
I think that if people really look, this is not a sexy issue. I mean, this is not
398 to 21.
No, this is not a sexy, in my judgment. The man on the street doesn't care a lot about this issue. This is not C-chip. This is not Abu Ghraib. This is not a sexy issue, and I don't think that of the 390 people who voted for this bill, there were 7 of them who read it. Now, George is a lawyer. He read it, and he hasn't read it correctly. It's a complicated bill.
So you think the Senate will read it?
It's a poorly drafted bill. I think this is not. There's not a lot of excitement. I think the Justice Department is dead against it. As well they should be. They're concerned with their role.
Why are they dead against it if they have guidelines that say the exact same thing?
No, because
so why could they be against it?
That's because you haven't read it carefully, George. If you go back and read it, you'll see that
Jim introduced me as saying that I wrote the damn thing. How couldn't I have read it?
It says, listen to me, it says that if the information you want will reveal a source, then you're way beyond the justice guidelines. If it's going to reveal a source, you got to show imminent death or bodily injury or
we're
harm
talking about
to
the
national
Senate.
security.
That's not true in the Senate bill.
Gentlemen, we have come to the end, and I'm going to ask you the question. Will Bush veto the bill, and will the veto be sustained?
If he has any sense, yes. And if he intelligently, which is maybe beyond his capacity, if he intelligently explains his position to the Senate and to the House, the veto will be sustained.
Thank you very much for coming by, Marty London.
My pleasure.
Right. George Freeman, will he veto the bill, and will the veto be sustained?
I think the answer is that if the bill gets to the Senate floor, it's going to get there with the power to be able to beat a veto. In other words, they're not going to let it go to the floor unless it has enough votes
he will veto it.
to sustain it. I don't think he'll veto it in
You
the
don't
end.
think he'll veto it?
I think he has enough problems that he doesn't need yet another conflict.
Right, George Freeman.
Thank you, Jim.
Thank you very much for coming by.
Pleasure.
And thank you for coming by. And come by next week to learn more about the digital age. For the digital age, I am James Goodale. Good night.